Hi, my name is Gennady Litvin, and I'm an attorney with the Law Office of Yuri Moshes. Today, I'll briefly talk about what is sexual harassment, specifically same-sex sexual harassment. Now, despite the existence of laws prohibiting sexual harassment in the workplace, sexual harassment is nonetheless very common, including male-on-male harassment and woman-on-woman harassment. Now, even though federal law does not explicitly prevent same-sex gender-based harassment in the workplace, more and more courts are ruling that sexual harassment Title VII law applies equally to same-sex harassment, especially because of the recent current events. What is sexual harassment? When most people think of sexual harassment, they think of harassment of one member of a particular gender, normally women, by the other gender, normally men. But sexual harassment is not a legal rule based on different genders. It is anyone because of his or her gender. In other words, the law primarily seeks to protect victims that have been harassed no matter what their gender is. This means two things. First, any person can be sexually harassed, male, female, or otherwise. Second, perpetrators of sexual harassment cannot get away with harassment simply by choosing only to harass members of the same gender. Actionable workplace sexual harassment can occur in two instances: quid pro quo sexual harassment and hostile work environment sexual harassment. Quid pro quo sexual harassment is the type of sexual harassment that most people think of as illegal. Quid pro sexual harassment occurs when an employee is subject to unwelcome sexual conduct, and her creation to the conduct is that used to be the basis of decisions affecting the compensation, terms, conditions, or privileges of her employment. Now, in other words, the employee must establish that a tangible job benefit or privilege was conditioned on an employee's submission to sexual blackmail, and that adverse consequences followed from the employee's refusal. The issue in quid pro quo cases is whether the supervisor has expressly or implicitly linked tangible job benefits to the acceptance or rejection of sexual advances. While overt requests from sexual favors are of course prohibited, so too are implicit sexual pressures and harassing conduct. Hostile work environment sexual harassment occurs when the workplace is filled with sexually discriminatory offensive comments and actions that are sufficiently severe to change the conditions of the employee's work environment. For example, frequent lewd jokes or emails containing pornographic images can create a hostile work environment. Sexual harassment claims cannot be initiated simply because an employee finds one particular comment or joke offensive. There must be a continued pattern of workplace harassment. Now, what are the common signs of sexual harassment? Sexual harassment comes in many forms, and it is impossible to compile a complete list of the types of activities that are considered to be sexual harassment. But as attorneys, we do see some forms of sexual harassment a lot more than others. Amongst the most common forms of and examples of sexual harassment are jokes or insults about genitalia, lewd comments or taunts regarding bodily appearances, jokes or comments about the victim's clothing or fashion style, the sending of sexual cartoons or pictures in letters, emails, memos, text messages, social media, verbal sexual assaults such as threats of rape, sexually suggestive simulations such as pelvic thrusting, flirting or unwanted sexual advances, demands for dates or sex, wolf whistles or catcalls, comments or questions about the victim's social life or sexual life, and physical sexual assault, which can also be a criminal act. What are sexual harassment gray areas? Is hazing and horseplay considered sexual harassment? Hazing is generally considered to be attempts to embarrass another person, either force someone to humiliation or do humiliating things, while hazing includes sex-related behaviors or interactions. They may not necessarily be motivated by gender, but rather may be considered bullying. For example, workplace horseplay, where coworkers have a running joke of catcalling each other, might technically be sexual harassment. However, where the behavior is accompanied by sexual undertones and it affects the victim's ability to work, it could rise to the level of sexual harassment claim. How are you protected by the law? As a matter of federal law, Title VII protects victims from sexual harassment based on one's gender. However, Title VII only applies to employers with 15 or more employees. All small employers who employ fewer than 15 individuals are exempt from Title VII's requirements. Many states and localities, however, do have laws prohibiting same-sex workplace sexual harassment. For example, New York State and New York City law protects victims of same-sex sexual harassment by covering employers with 4 or more employees. This means even small companies employing fewer than 15 employees, victims of same-sex harassment can file a sexual harassment claim against their employer. An experienced attorney in New York that handles sexual harassment matters can explain how these federal, state, and city laws apply to your case and help present your claim in the most favorable light. What should victims of same-sex sexual harassment do? First, victims should make the decision to speak up. Workplace abusers and harassers need to be reported. Otherwise, justice will never be served for that victim. Additionally, many harassers will repeat their actions and harm others. In fact, 2 U.S. Supreme Court decisions addressing sexual harassment make reporting workplace sexual harassment somewhat mandatory. In fact, an employer is not liable for sexual harassment in the workplace where the harassed employee unreasonably failed to utilize the employer's sexual harassment complaint procedure. So you should always complain, though. And it only applies where the anti-harassment policy is regularly enforced and the employee was not fired as a result of the harassment. However, it is always a safe bet to report the sexual harassment pursuant to the guidelines and policies and procedures of the employer, just in case that defense may apply. Second, once you do begin talking to either HR or your boss, be consistent. Always tell the truth. Only tell the truth. You do not need to exaggerate what has happened to you. One of the reasons why HR investigations do not succeed is because the investigators did not find the victim to be credible. Being caught in a lie or changing your story will destroy any credibility you ever had and will make fighting a subsequent legal battle more difficult. Third, you should take the time to educate yourself on sexual harassment and sexual harassment law. Make sure that you know your rights and what you need to do and what evidence you need to preserve that you may have. If you're unsure on how to do any of this, you should contact an attorney to assist you in helping you gather the evidence and put together the claim. What is the typical type of evidence of sexual harassment claims and how do you get it? In general, sexual harassment lawsuits require evidence to make a successful claim. Fortunately, your word and your statements as a victim count as evidence. Unfortunately, if all you have is your word, the case will be more difficult to win because it will only depend entirely on your credibility versus the credibility of your harasser. It's not a good place to be during trial, and many cases lose for that reason. You can improve your case by gathering either direct or circumstantial evidence. Direct evidence is the most straightforward way of proving a sexual harassment claim. Direct evidence is any evidence that directly proves your claim. For example, emails or text messages containing sexually explicit jokes or sexual advances sent to you by a harasser, social media posts or conversations, eyewitnesses to the sexual harassing behavior, recorded conversations or security camera footage, and physical evidence such as prank items or lewd items or ripped clothing. Sometimes the harassment is not as blatant as the examples given above. Instead, circumstantial evidence will need to help prove that you are telling the truth and your employer is lying. This type of evidence is known as circumstantial evidence. While it can be more difficult to prove a sexual harassment claim based only on circumstantial evidence, it can still be effective. For example, if a supervisor asked to have sex with an employee and the employee refused and then was fired the next day, it's reasonable to assume that there was some sort of implied threat attached to the consent for the sex because the events happened very close in time. Another example of circumstantial other employees were treated similarly in the past by the same supervisor or employee. The more circumstantial evidence there is to support the link between the proposition and the firing, the stronger the employee's case will become. What happens if an employer retaliates after the reports of sexual harassment come in? Often sexual harassment cases also involve retaliation against the victim for complaining of the sexual harassing behavior. Retaliation against any employee for reporting such behavior is illegal under Title VII. U.S. Supreme Court actually held that a plaintiff must show that a reasonable employee would have found the challenged action materially adverse, which in this context means it might well have dissuaded a reasonable worker from making or supporting a charge of discrimination. A materially adverse action could be getting fired or terminated, being demoted or getting a salary reduction, receiving negative performance and evaluations and negative references, or receiving a substantial change in shift assignments or job assignments. Same-sex sexual harassment reports are becoming increasingly common as more victims come forward, evidenced by the Me Too movement. The law office of Yuri Moshes is based in New York and New Jersey. We offer a free consultation in confidence and confidential to all victims of sexual harassment. If you have been harassed in the workplace, contact our law firm and allow us to help evaluate your case. We are here to help you. You can always reach us at 718-504-6090. We look forward to working with you.